former ANO Special Global Counsel Philip Wood QC and ANO alum John Fisher. Following on from John's session as part of Alumni Week, Collapse, How Civilization and Law in England Chose to Fail and Then Succeed, Philip will discuss how events since 1830 are key to the understanding of legal systems in the 21st century. Philip will explain how we got here and where we are now in world law. John will conclude the session on the topic of Roman law and civilization. I will submit any questions that come through to Philip and John at the end of the session. I will now hand over to John and Philip. Thank you.
Good afternoon. As we are covering 2,500 years of the history of law and Western civilization, I suggested in November that there was too much material for one talk. Philip was agreeable to take in the story of world law up from where I left off with the reception or the receiving back of Roman law in the 12th century. Before handing over to Philip, I'll give a brief recap. Our history of law begins in 509 BC with the overthrow of the kings by the Romans after the rape of Lucretia by Tarquinius and the foundation of the Republic. The Romans vowed that never again would they have kings. As during the medieval period, the king appointed and dismissed judges, indirectly the king could make law, which Roman law can never accept. This is the great divide between common law and civil law. A definition of common law would be judge-made law, or law based on previous cases. Civil law must always be made by Parliament or the equivalent. In 450 BC, the Roman popular assemblies and the Senate passed the 12 tables. You cannot have law without a system of bringing a defendant to trial, jurisdiction, court procedure, and the execution of judgments. These are all dealt with in tables 1 to 3 of the 12 tables. Unless a court judgment can be enforced, you do not have a legal system. Judgments would only have moral authority. So here you have the bedrock of all legal systems. The word civilization comes from the Latin civitas, or a city. The importance of law to civilization can now be seen clearly. Celtic England consists of settlements in the lowlands and oppida or hill forts, no cities. In the invasion of England by the Romans in 43 AD came cities and Roman law. With the foundation of cities, society had to move to a services economy. Sale of goods alone would not work. There were all manner of services, including many of those things which we today would call culture or civilized life. For example, my copy of the Iliad, the foundation of all Western literature, is about 550 pages long. It is too long for one stage performance. It is thought this was sung in Roman amphitheatres and theatres over a period of 3 daily performances, rather like Wagner's Ring Cycle. Singers would take the parts of Achilles, Hector, Agamemnon, etc. However, this has got to be paid for. So with services, you have to have a money economy. Barter would not work. For services, you had to have a legal system. People would not provide services on credit unless they knew they'd be paid. And if the debtor did not pay, then they could get judgment against him and execute against his assets. By the 5th century, England was as Romanized as any other province and very prosperous. Then in the 20 years after 410 AD, when the Romans left England, came the collapse of civilization, the abandonment of the cities, the collapse of the money economy, and the abandonment of Roman law. Most severe in England, but a similar collapse, although less severe, happened in Gaul, Spain, Italy, and later in the East, and the Roman Empire gave way to the Byzantine Empire. In the Dark Ages, the church saved civilization after a fashion, as it wanted to hang on to its wealth. For this, you needed a legal system. By the 7th century, Roman law had been forgotten in Europe, but in its place came the primitive legal codes, such as the Visigoth, Burgundian, and other European law codes. Today, these codes are known as vulgar Roman law. Thus, the concept of wills and codicils and the deed from Roman law can be found in the vulgar law codes, and were reintroduced to England by the church. However, these vulgar Roman law codes were far too primitive to be crucial for civilization. Something far more detail was needed. Meanwhile, in 533 AD in Constantinople, Justinian produced the Digest, which was by far the most important part of the Corpus Juris Civilis, body of civil law. In 3 years, Justin's jurists copied and pasted 1,000 years of Roman law contained injurious opinions by reducing them from 1,500 books, about 30 times the size of the Bible, to 50 books. Even after this, the digest was still 1.5 times the size of the Bible. This is the detailed legal code you need for civilization. Many people think that Roman law was based on Greek law. Roman mythology, the gods, architecture, philosophy, and much else, of course, came from the Greeks, but not law. The Greeks are more into philosophy, which included jurisprudence, than the detail required in law. They had a legal system, but again, it was too primitive to be crucial for civilization. From the end of the 6th century AD to the 11th century AD, Justinian's digest was lost. So customary law and the primitive vulgar Roman law codes took over for at least 500 years, which in England included feudal law. At the start of the Renaissance in about 1070, a 6th century copy of the digest was found in Amalfi, Italy. Today it is in Florence. The importance of the digest was immediately recognized. It was glossed or annotated by the law school at Bologna University, and the reception or the receiving back of Roman law swept through Europe and started to sweep through England from the 1140s. However, the English were a new, precocious civilization. We were going to do our things our own way. In 1154, a fierce debate took place as to whether or not English would follow the reception or have its own unique legal system based on cases. We have a transcript of this debate. The receptionists lost the debate. We have a common law system, which has been to our inestimable benefit, as it allows the law to be changed quickly. However, lawyers have a natural liking for precedents and do not want to reinvent the wheel. Whilst Roman law can never be a source of English law, from the 12th century onwards, judges introduced it through the back door. So we have the best of both the common law and the civil law legal systems. Over to you, Philip.
Thank you very much, John. And thank you to everyone for attending this session. Thank you very much indeed. Now, I have now got to cover another 1,000 years or so. So I'm going to take this at quite a pace. And I'm really going to try and work out what happened to Roman law. The legacy of Rome was not its amphitheaters or its aqueducts or its military discipline or its legions or its philosophy. It had two great legacies. One is a religion, which was spectacularly successful. And that was introduced by Constantine after the Battle of Milvian Bridge, but really it was Theodosius later who made it the religion of the Roman Empire. And the other legacy were its laws. So I'm really going to talk about those laws and what happened to them and what happened to that legacy, whether it disappeared or it didn't. And in order to do that, I'm going to go around the world and introduce you to the jurisdictions of the world so that we can trace this progress. Now, there you see before you a map of the world. There are 320 jurisdictions there, according to my count. A jurisdiction is a territory which has population, de facto government, and a separate legal system, more or less, from everybody else. So the Bouvet Island, which is a Norwegian island, the most remote island down in the world, down in the South Antarctica, is not a jurisdiction because actually nobody lives on Bouvet Island, and I don't think anybody would want to live in Bouvet Island. But in the British Isles, there are 7 jurisdictions which do not include Wales, but there are 7. And I used to offer a bottle of champagne at lectures to anybody who could get all 7 by the end of the lecture. Nobody ever won it, but of course now they can just look it up on Google. Now, in fact, there are really only about 252, because if you concertina all the American jurisdictions and all of those in Canada and Australia as well, and teach those countries as a unitary system, you get 252. About 200 nation states, just under 200, I think 198, 199. The latest are Montenegro, East Timor, and South Sudan. So there's been a slow creep up in the number of sovereign states, but embedded in these are often several jurisdictions in one territory. Next slide, please, Forum. That's it. Now, this map it took me about 20 years to work out this map accurately. And I think that this portrayal of the world is the key to understanding comparative law. It's the key which opens the door so that the light can shine in. And I think it's important because nowadays, we're only trained and qualified to practice in one jurisdiction. But nowadays, we really have to know them all. And we have to have a feel about how they work and what the differences are, because legal systems are ideologies. And because of their history, the main legal systems are very different. And so anybody who works in an international firm like A&O will often handle, the firm as a whole probably will deal with 200 jurisdictions a year easily. I once did a count, and I thought it was practically every jurisdiction. In that particular year, we even dealt with the Vatican. So I think it's extremely intricate and widespread, the range. For some reason or other, I used to get students to, give them a blank map when I was teaching at Oxford and Cambridge. And I got them to color in. I said, you've got these groups and color them in. You've got the English common law group, the American group, the Napoleonic group, the Roman Germanic group, the mixed group, the Islamic jurisdictions and so on. And there were two jurisdictions. I mean, they found it quite easy to follow it once you'd explain the principles. But there were two jurisdictions they almost always got wrong, which were Israel and Malta. Now, let's go to the next slide. And I'm going to take you just on a short tour so that you can get fixed in your mind what the groups are. These are the American common law jurisdictions. There are 61 of them. And mainly, it's the US plus 10 very small, mainly island jurisdictions, which are bases, including Liberia, which for historical reasons, which you'll understand, is part of the American group, and they track Delaware law, and they track various other aspects of US law. Now the United States is not a territorial empire, but it's an empire of the mind. And one of the great pivotal moments in human civilization was 1492. And the leadership of 1492 in what became started off as an enormous imperial movement. The leaders were actually Spain and Portugal. Portugal in 1487 had got round the Cape. And up till then, there certainly had been some pretty enormous empires. The Roman Empire itself was huge. It was all around the Mediterranean, up into Europe and into the Middle East. Alexander the Great had a big, but very short-lived empire. It collapsed, almost, a few months after he died. And a very big empire after that were the Muslims, a huge empire of the, they burst out in the 7th and 8th centuries and really took over almost all the world, from Spain. They even got as far up as Tours and Poitiers, all the way through to China, with large parts of northern India and almost the whole of Asia. An incredible thing to happen. And unlike the next big empire were the Mongolians, and they had an empire even bigger than the Muslim, just huge, to Eastern Europe, because it then included China as well. And so Tamerlane and Kublai Khan, Genghis Khan, had a vast, vast area. And the difference between them, the Mongolians, and the Muslims, the Muslims left quite a sophisticated legal system, but the Mongolians didn't. And so there was always going to be a bit of a tussle between the Roman laws and the Muslim laws. And that's a tussle which is still playing itself out in the modern world. Now let's just go to the big empires, the big law empires. Next slide, please, Forum. Now you can see this group here. This is the English common law group. It's mainly composed of Australia, Canada, a lot of islands, and of course, India, Pakistan, Bangladesh, and Malaysia, and a lot of African territories. One of the main attributes of this group is that the original founder of the group, which is England, its legal system is used as an international public utility. And that means that together with New York law, it's thought about 80% share of large syndicated credits, derivatives, international bond issues, and similarly for large contracts like charter parties and long-term sale agreements and some intellectual property licenses. So they're used now, they no longer belong to English law, no longer belongs to England. England really just looks after it. And that means that the international business community has a sort of vote, you know, an informal vote on what English law says. And in order to maintain that status, which being an international public utility has, which confers quite a lot of soft power and hard power as well, is quite important for the English courts to take account of what the international business community thinks. These two legal systems are, if you like, a kind of monopoly. And monopolies are not a good thing because there should always be competition. But they're a monopoly in the sense that Delaware is a monopoly, because I think 70, 80% of the New York Stock Exchange are incorporated in Delaware. The UCP 600 is also a monopoly. The SWIFT is definitely a monopoly, and the ISTA master agreement is a monopoly, and I think the LMA form has an enormous amount of following, except in the United States. And so those monopolies tend to work provided that they deliver what the users want. And the room for making gaffes or mistakes or upsetting the people who use the monopoly, there is a fair amount of tolerance, but not all that much. Could we please have the next slide? Now this is the Napoleonic group, founded in France, together with a lot of help from Spain. You can see it's one characteristic of the group is that about half of it was introduced voluntarily. So the whole of Latin America and the LATAM region adopted the legal system voluntarily. And the others, you know, it was imperial, and it was the Foreign Legion who imposed it. Now, the legal system, which was developed by France, was settled in, the Civil Code was settled in 1804, and the insolvency codes were a little bit later. And it was incredibly charismatic, and it still is. Stendhal is said to have read some lines of the code every day to refine his feeling for the language. And the charisma of this legal system, because of the way they did it, made it firstly very indelible. It's been very hard to make great changes in what happened in 1804. And that is a good thing, but it also prevents progress being made. And in that sense, these great religions are not just ideologies, they're a bit more than that. They're almost like religions, and they have the indelibility of a religion, because once somebody says something with enormous conviction, people tend to cling on to that. An example of why of its charisma is that 17 sub-Saharan African countries have adopted a uniform shortened version of modern French business law. It's called OHADA, based on the Ivory Coast. And so that's an amazing achievement for a former colonial power. And I think one of the tests, when you test the acceptability of these imperial ideologies, the question is, what did the post-imperial world do with them? Did they reject them, which of course they had power to do, or did they accept them? And on the whole, France has had a very high rate of continuous with what they originally promulgated. I think in English law, slightly less so. I think countries like India had problems with the sort of hard edge of English law at one point, but it's got very enthusiastic following in places like Hong Kong and Singapore. Now, next group, let's look at the next group. Now, this is the Roman Germanic group, based on German and Dutch law. It is mainly a legal system which has been introduced voluntarily, and that was because of the enormous quality of the product. It's interesting to note, which very much shown in this group, that when people achieve independence or have a big different cultural movement, one of the first things they do is to look around for a legal system which they can use. And so they borrow someone else's, they import one. It's much easier to import somebody else's legal system than to build one up from scratch. To build it up from scratch is really, a 500-year job. And so they look around for who's got the latest legal system. And so when Latin America achieved its independence after the Napoleonic Wars, they looked around for the latest legal system, which happened to be a very conveniently done and charismatic European system, the Napoleonic system. And basically, via Spanish laws, they basically imported that. And when Kemal Ataturk was looking around for a new legal system for Turkey, which he was reforming, he said, who's got the latest? And it happened to be the 1809 codes from Switzerland. So the commercial code in Switzerland and Turkey are almost identical. And when Yeltsin was advised by the IMF that he needed a market system of law, he also said, who's got the latest? And at that particular point, although it hadn't actually been adopted by the country concerned, they used that as the basis, and that was, as I'm sure you all know, they all packed their bags from Russia, from Moscow, and they went across to the university city of Leiden with their vodka, and they more or less took down what had been just prepared for them by Professor Mayers in Holland. And it was that basic civil code which was then spread throughout the former USSR. So it's a very common occurrence, this borrowing, and the borrowing is going on a very, very large scale. For instance, security interests are now being modeled in something like 130 jurisdictions on the basis of Article 9 of the Uniform Commercial Code, which is very convenient. Now, the next group I find quite an extraordinary group. Could we have a new slide, please? Now, this is the mixed group, and a mixed civil common law group. And I think it's astonishing to see in the same group Swaziland or Eswatini, Panama, Liechtenstein, Jersey, and Quebec in the same company as Japan and China. But that's part of the, the sort of humor of history. And if you worked out how that's happened, it would be possible to do that. Panama, because of the canal, so they introduced the trust. Quebec, because they're part of it, they were surrounded by English common law jurisdictions, and so they tended to be pushed in that direction. Jersey, because it was in the wake of Britain, and the South Africans, the Cone jurisdictions in South Africa, because they brought down with them a very advanced commercial law, Roman law, but highly commercialized, from Rotterdam and Amsterdam at the height when Holland was the leading financial center in Europe. And then, of course, in 1803 or thereabouts, the British appeared in Cape Town, and so they overlaid it with their own system. So by introducing trusts and things like that. So this is a remarkable group because it is a fusion. And you could say, is that the fusion which we're looking for? Is that melding of the civil code and the common law jurisdictions? Is that the way forward? And I think that is a question which still has to be answered. Now, if you go on to the next group, please, the next slide. Now, this you see is the Islamic group. It's quite small, and it's only got 11 jurisdictions. The English group has got 84, the Napoleonic group 86, the Roman Germanic 34, the mixed 18, and then Islamic quite small. And that's because the main countries which you'd think were Islamic, like Iran, Iraq, in fact are not. They're underlying Napoleonic, but they've got an Islamic article at the beginning of the codes which says anything inconsistent with Sharia is void. But underneath, Lebanon, Jordan, Iraq, and Iran are basically Napoleonic because of the mandates between the wars. Just to mention that Israel is an English-based jurisdiction, but Jordan is not. It's French-based, and Malta is actually Napoleonic, not British. Now let's go on to the next group. Next slide, please. Now these are, I call them the new or transition jurisdictions, because I'm not quite sure yet that they've really settled what their directions are. They seem to be missing decisions on some pretty crucial aspects of law. So I think we might have to wait, another 50 years or so before they can settle down. I now put Russia back into this group because I think they are really, on all of the indicators I use, I think they're part of the group. Now, there's just one more group I want to mention. Next slide, please. Oh, no. Is there a slide before that? No, okay, doesn't matter. They were just an unallocated group. We don't have to follow them. Now, let's go on to the next slide. Now, this slide I find really remarkable. It is an incredible generalization. But nevertheless, I think there's an enormous amount of truth behind this panel. And when I first worked it out, I was astonished that we had that kind of result. The way I work out comparative law is I use key indicators. You can't go through the whole legal system. And the key indicators have to have 4 characteristics. The first is you had to be able to measure them. The second is they had to be very important, economically important. The third, they had to be symbolic and representative of an overall view. And the fourth, they had to show conflicts, not the same. So vast areas of law in those particular 3 groups are the same, offer an acceptance and agency law. I mean, they're pretty much the same. Not enough for you to feel that there's a different set of risks involved. Now, now if we just go on to, I'm only going to pick 3 of these indicators. One is set off, the other security interest, and the third is trust. They're all systemic, they're of systemic importance. They all involve absolutely enormous amounts. Closeout netting involves just trillions because of derivatives and foreign exchange. The biggest trust in the world has got securities which are about 1.5 times world GDP. The biggest trust in Europe has securities equivalent to the GDP of Europe. There are Depository Trust Corporation and Euroclear, and the amounts of security interest, the main fields of which are home mortgages and financial collateral, are enormous, but not enormous as they could have been because security interests are not used by public companies. So let's just skim through those legal indicators and see what the world looks like. Next slide. So since insolvency set up, so you can see there's not a lot of agreement on the world about whether that should be available. And the disagreement results from the fact that a set-off involves a depletion of the debtor's assets and a violation of the pari passu principle. And I want you just to note the difference between Russia and China, who took a completely different view on this issue. Next one, slide. We'll do the next one. These are security interests again. You can see a massive splintering disharmony around the world. Next one, please. Now this is the trust. The argument about the trust has now been rumbling along for a good 1,000 years. It's surprising that we still haven't resolved it. The basic idea of a trust is that if you give an asset for somebody else to look after and they become insolvent, then you get your asset back. And in all of the world, you do get your asset back if they are goods. If you put your goods in a warehouse and the warehouse goes bust, you get the goods back. That's effectively a trust, but that doesn't apply to land and it doesn't apply to investments, intangible movables, in about half of the world. And so that's truly amazing that we have that situation. Now, the reason I show those indicators is because there is those are the triple super priority creditors on insolvency, which is when you test the credentials of a civilization. They are the claimants who get out completely to the extent of their assets. And all three of them destroy the basic idea of pari passu payment on a disaster. And the three of them are present in all of the common law jurisdictions, and half of them in the Roman Germanic, and none of them in the Napoleonic, except for the carve-outs, because there are a huge number of carve-outs, like the Financial Collateral Directive for financial markets. So that what's really happening is that the underlying situation remains, as I've shown you, but with a massive strengthening at the financial sector. And you could say, well, how actually did this happen? And I know people made a lot of, the culture of countries, which is why they're different. Some are pro-debt or pro-creditor, and that kind of cultural thing. But I don't think that that's really what happened. I think that what happened was that the timing of the crystallization of these jurisdictions' ideals, their ideology, in relation to the onset of the Industrial Revolution. So the Napoleonic codes were the first. When the Industrial Revolution, I mean, it hadn't sort of really happened at that point. And so they installed codes which had things like security interest weren't all that important. Money lenders preying on agricultural people were not regarded as very important, not worth looking after them. And certainly insolvency set-off was relatively unimportant because you didn't have central counterparties and payment systems and massive derivatives and massive numbers of reciprocal contracts between traders and bankers and so on. So it just didn't occur to them that that was a major point to be dealt with. As I said, once somebody had said something with indelible conviction, then that tends to stick. But meanwhile, before that, the English Industrial Revolution had taken place, and they developed their legal system settled during the 19th century, at the time when the philosophy was the invisible hand of the market. Adam Smith capital is king, railways must be built. And it was that attitude which produced their particular view on those triple super priority claimants. And meanwhile, Germany, who installed their codes, their bankruptcy code was 1879, it lasted for a century, and they installed their civil code system in 1900. So it was put together at the end of the 19th century. And they had, the Industrial Revolution had already taken hold in Germany, but the codes were drafted by lawyers who were steeped in Roman law, the ancient Roman law, and who were not altogether sympathetic towards trade and finance, and banks. So that's why, in my view, I think that's the right explanation of why one legal system is red and one is blue. And if you say, in what direction are they moving? I think those groups are now moving towards the blue. And that's because of the financialization of the world. And that's because I think those institutions of a universal security, which is easy enforceable, of closeout netting, and having some means of custodianship, for example, are very important to economies. That's my view. Now, if we sort of stop there and look at the position of Rome in all of this, we now see that although it's often said that English law was not Roman, in fact, it was highly, in my view, influenced by Roman law. I haven't got time to go into the issue, but you will see now that the Roman Empire and its laws have now developed into the foundation of 85% of the world's jurisdictions. And that's because 85% of the world's jurisdictions are based on 3 Western European countries in the main, plus certain help from others. Those are England, Germany, with help from Holland, and France and Spain. So that's now another spectacular achievement. And that shows what a general ideology can do. But we now see that the ideology has split, it's splintered, like a stone hitting a windscreen. But at least if we apply this method of putting the legal jurisdictions into families, then we can more or less begin to work them out, because you only really have to understand the 3 dominant legal systems plus New York. Next slide, please. Next slide after this. Now, working from 1830, you will see here that I've mapped together the growth of law compared to the growth of GDP and the growth of population. The population of the world in 1830 was 1 billion, and in 1930 it was another billion, and then it accelerated very quickly, so it is now 7.6. That's multiplied about 7 times since 1830. A GDP in 1830 was about 700 billion in dollars. That's the same size as Australia, South Korea, and now it is 80 trillion. So that's about gone up. Is that 1,000 times, 100 times? I get lost in all the noise. But it's gone up much more than population has, because more people create more things and do more things, invent more things. And so the football fields of GDP in 1995, if we put football fields of 10 trillion each, in 1995, the US was 1 football field, and then the other was Europe, and then the rest of the world was the 3rd football field, half of which was taken up by Japan and what were then called the Eastern Tigers. Now we have 8 football fields with a very, very different spread, and in the future, we may have 15, 20, 50 football fields. And what that means is that GDP is an expression of money. So that's the work of the people. It's their work which translates into GDP. And all that money is not going to go under the mattress. And so it's going to go into companies and mutual funds, and it's going to be used. What's called the financialization of the world. What will that lead to? Probably more crises, certainly more prosperity around the world, but also more crises with all of that money slashing around. And when you have a crisis, The first thing that people do is they reach for the legislative wand. Now, if you said how much has law increased since that time? Well, we know Hammurabi had 232 articles in 1732. We know Moses had 10 bullet points on his mountain. We know how long Justinian's codes were. We know that the tax code in 1840 was in the US was just a few pages. But now we have massive corporate and regulatory law. And so really the amount of law has completely got out of control. So let's now move on and see what the next directions are going to be. Next slide, please. This is a very famous picture. They are obviously fighting for something. Everybody is fully armed. This picture hangs in the Louvre. And the question for me, that is an allegorical picture. Everybody is in it, the merchants, the youth, the workers, and they are looking for freedom and liberty. And the question is she right? Is the lady, and are they right? Now we look at the next picture, which is a highly iconic picture from which shows the wreck of the Medusa, which the Medusa sank about 90 kilometers off the coast of Senegal and Mauritania, and 147 people got on that craft and 15 got off. Next picture, please. This is the Chilean miners. Those miners found themselves at lunchtime under half a mile of rock on the 5th of August 2010, 33 of them. And the difference with the Chilean miners and the raft of the Medusa is that all the Chilean miners got out, whereas in the case of the raft of the Medusa, very few people survived. You can say, what's the difference? Well, one of the differences, I know there are many others, is that the first thing the Chilean miners did when they found they were trapped is they elected a leader, and the leader made rules about the food. So they set up a constitutional government and they had laws. And that's one of the reasons why they survived, because they're down there for 69 days, whereas the people on the raft were only there for 12 days. And the people on the raft had no rules. The captain left the ship, so they had no head of state, and they had no rules at all. And most of them were killed not from thirst or hunger. They were killed from the fighting for the brandy and the biscuits. So you will say, why do we have law? We have law in order to survive. And we can't have a society nowadays without a legal system. It's fundamental to our legal system. You couldn't have a society which just relied on mutual tolerance and forbearance and an understanding between people, because how would you have a tax system? How would you have contract? How would you have insurance? How would you have a law of dealings? You couldn't have it unless you had laws, and that extends even to money, the law of money, banks, and corporations. So if we go back to Rome now, the first point is that Roman law was an ideology, and it was an important ideology, and because it represented the values and the ethics and the moral convictions of the people. And laws now, laws of taxation and so on, are drenched and saturated with morality. So effectively, legal systems are now embedded moral systems. And so if you say the legacy of Rome was its religion and its laws, in fact, it left its laws as a religion, because now the law is the summary, the most exhaustive and detailed summary of our norms, our ethics, and our morals. Thank you very much. John, have you got anything to?
Yes, I'm going to speak for a few minutes about Roman law and civilization. I've said that generally speaking, all 321 legal systems of the world are based on Roman law. None are indigenous. The whole of Roman law is contained in that 6th century copy of Justinian's Digest, which was discovered in Amalfi, Italy in around 1070. We drill down to the next level, as Philip has said, generally speaking, These jurisdictions can be subdivided into common law, the French and the German legal codes, etc. Just to complete a global survey of legal systems, we know that former colonies of European countries have adopted their mother country's legal systems. The astonishing thing is that all former non-colonies, e.g. those in the Far East, China, Japan, Thailand, Korea, etc., have adopted either the Napoleonic Code, the German or the Dutch legal codes, whichever was the latest when the decision to adopt was made. Incidentally, adoption of a code means you cannot go back to principles or case studies which predate the code. However, there are a number of civil law countries who have not adopted a code, e.g. Scotland and South Africa. It means in theory you can go back to Justinian's Digest, and sometimes judges do. What is remarkable is that not only did the Romans never go near many of these countries, but 2,000 to 3,000 years ago, China, for example, had a much more advanced civilization than we in the West. Yet such was the brilliance of the Digest, but generally speaking, they have based their law not on this and not on legal principles they developed. Sorry, they've based their law on the Digest and not on legal principles they developed themselves. Just recently, deeply influenced by Hong Kong and Singapore, China has adopted our trust law, lock, stock and barrel. Recently, France, now for the third time, introduced the general law of trusts. Thus, with a general knowledge of Roman law, we can have a working knowledge of all the world's legal systems. This in itself would be a good reason for studying Roman law. Justinian's Digest contains statements of principle and thousands of actual and theoretical case studies, fairly similar to a standard English legal textbook. Here is one case study from the Digest. If A supplies copper and B supplies tin to C to make a bronze statue, both retaining a legal title over the metals until payment, and C goes bankrupt prior to paying A or B, and leaving other creditors, who owns the bronze statue and in what proportions? We immediately recognize this as a Romalpa clause, or trace of mixed goods at common law. Roman law is far more rigorously analytical than English law. Even if you are just an English solicitor and do not have to consider the laws of any civil countries, in my view, you are a much better solicitor with a good working knowledge of Roman law. All of us know that there is a huge difference between an excellent solicitor and an okay one. In my view, a good working knowledge of Roman law can make you become that excellent solicitor. Therefore, Roman law is great for career development. It's not as difficult as you may think to acquire this knowledge. If you take notes on the well-written Introduction to Roman Law by Barry Nicholas, a former Oxford Don, this will be sufficient. We can see the sheer brilliance of the Roman jurist by considering the law of slavery. Appalling though this concept is, consider this exam question. Was a slave property or a legal person in Roman law? People poo-poo this and say, what is the relevance of the law of slavery today? Of course, the slave was property, but also because slaves were often able people, in Roman law they had limited agency. Therefore, to answer this question, you not only have to analyse all the attributes attached to property, but also agency. A slave as property had to be bought with legal title passing to the buyer by using the conveyance of mancipatio. Because there was no paper in the Roman Empire, originally this was an oral conveyance, which to be valid required 5 witnesses. During the empire, it became a paper transaction, or should we say a papyrus, animal hide, or writing tablet transaction, because the IP of papermaking had not yet been stolen from the Chinese. You may say this is fairly straightforward, but here comes the brilliance. To emancipate a slave, again the conveyance of mancipatio is used, but this time the seller was the slave owner, and the buyer was the slave. So property or legal title in the slave passed from seller to buyer. As the slave acquired legal title in himself, he was a freed man. Tricky tracing of mixed goods and the law of emancipation are 2 examples of why there's never been a legal system to compete with Roman law. I give you a third. If the computer was invented 2,000 years ago, Roman law could have coped with this. Of course, there was no copyright or trademark acts. There was, however, the delict or tort of deception. Further, Roman law, unlike civil law, could change quickly to adapt to commerce. As there were 2 other sources of law, apart from lex or legislation, opinions of the jurists and actions by the praetors, who ran the legal system. The praetors had no power to make law, but had power to change legal procedures. So by changing legal procedures, they made law. Jurists were also on hand to advise the lawmakers. Accordingly, IT law could easily have been developed. Legal title to computer software, being intangible property, is transferred by assignment. If B owes A money, but B is owed money by C, then originally in Roman times, A would have to go to court to get a court order to transfer C's debt to him, as this was a chosen action or intangible property. Over time, however, the praetors allowed this to become a paper transaction, whereby B transferred C's debt to A. This is how the assignment was born. The key point to note about my examples is that in Roman law, there has to be a conveyance in addition to a contract to transfer legal title to any sort of property. It's actually the same in English law, but we've obscured this for goods by merging these two distinct transactions in contract law. I do not think this helps in us analysing a transaction. Under the common law, when a person dies at testator or intestate, a trust applies, even if it is only a bare trust. Under the 12 tables of 450 BC, the heir took over all the deceased estate, including his rights and liabilities, under the principle of universal succession. No trust was formed. Later and romantically, if the testator wanted to free his slave on his death as a mark of gratitude, as a slave was property, impose a trust or a fide commissum of this property on his heir by a letter of wishes. Fide means trust, and commissum means to instruct. The trustee was fiduciarius, hence fiduciary duty. The heir then entered into the conveyance of mancipatio with the slave, who became a freed man. However, the Roman law will trust had a much wider application than this and could be used to create a life interest, which Philip has suggested was often used for inheritance tax avoidance by skipping a generation. If as part of your practice you need to have a working knowledge of civil law, I would suggest you are in a similar position to a notary public. The phenomenon of being a notary is that you have many thousands of telephone inquiries over a year. On the phone, you need to ascertain generally the nature of the transaction and which country the documents are going to. Obviously, most would be for civil law countries, and you can apply Roman law to the transaction. Thus, the knowledge of Roman law is not only important for ascertaining the scope of the work and to price it properly, but you will not keep your first-class corporate clients unless you give a first-class service. Without this knowledge, you will make mistakes. In the fall of the priests and the rise of the lawyers, Philip explains that for over 1,500 years, religion held society together, until the 1850s when religion started to get out of fashion and law took over. The current COVID crisis is eerily similar to the Black Death in terms of where it came from, the speed of its travel, and the lack of cures at the time of its incurrence. We rightly mourn the deaths in World War I, and it is doubtful that we would ever accept slaughter on this scale to happen again. But this was less than 1% of our population. In the 17th century English civil wars, 6% of our population died. We were so sickened by this death toll that we led the world to the concept of politeness. You may violently dislike the views of your opponent, but this does not mean to say that you have got to kill him. In the 2 years of the Black Death from 1348, our population dropped from about 5 million to 3 million. Roughly 2 million of our population died, which was about 40%. The difference between the Black Death and COVID was that in 1348, religion held civilization together. Now we only have law. Thus, law is even more important for civilization, and it is surely our responsibility to explain why. No one else will do this. As A&A is an international firm, it could kill many birds with one stone if it had an annual lecture, say, on Roman law and civilization, given by a distinguished civil lawyer. It should be possible for this to be accredited for CPE purposes and hopefully also for notaries. David Sutton has very helpfully drawn to my attention the enormous contribution to English law made by civil law lawyers. There was a contribution of lawyers who left Germany in the 30s and settled in England. Professor Clive Schmidhoff and Dr. Francis Mann spring to mind. They were followed some years later by other remarkable lawyers like Sir Sidney Kentridge and Lord Johann Stein, who practiced Roman law in South Africa before coming to practice at the English bar. And today, amongst our arbitrators, we have in one chamber Lord Angus Glennie, who practiced as a commercial silk in London before his appointment as a judge in Scotland, and Michael Tislentis QC, who practiced in South Africa as a senior counsel before coming to the English bar. First and foremost, of course, we have Philip. To conclude, I believe this is the first time that an understandable summary of the history of world law has ever been given in less than an hour. This in itself would be an explanation as to why role law has played in the history of civilization is poorly understood. However, I think that there are far more fundamental reasons than this. Many people in all walks of life, not just academia, have a poor awareness of any law apart from criminal. As Philip has explained, there is really no appreciation of how commercial law underpins civilization and always has always done so. The rule of law has always been a precious principle. It is even more precious today. As now that religion has gone out of fashion, only effective action from governments, mediated and backed up by law, can hold civilization together. What has been astonishing in the last 3 years is how England has been a laboratory test model for this principle. In Miller 2, we saw how the Supreme Court found the executive's prorogation of Parliament unlawful. In the COVID crisis, I've been surprised as how the law has been used and obeyed to battle a pandemic. This was why there was such an outcry over Partygate when the population thought that whilst they had obeyed the law, the executive had not. The law has been applied in minute detail on how we run our daily lives. This has prompted a lively debate by backbenchers in Parliament and by Jonathan Sumption on how the law is being used by the executive to curtail our liberties. Edward Cook's words to Parliament in 1628, Magna Carta is such a fellow that he will have no sovereign, could easily have been spoken today. The fall of the priests and the rise of the lawyers, Philip explains that the law is a noble profession. As it is crucial to civilization, it surely is.
Thank you. Thank you both so much for this session. During our talk, a few attendees have submitted some questions. I hope I can put these to you now. The first one is, how can we create an awareness that commercial law underpins civilization as, bearing in mind the current perception of commercial law at the moment, we surely have a mountain to climb?
So for me,
Not sure who wants to take that one.
well, I think with as one of the reasons why GDP grows is because people set up businesses, and the number of businesses in the world now is absolutely enormous, and they're the foundation of people's prosperity. The number of people in the world who now work on the land is tiny. I think the contribution to GDP is about 2%. 80% of the world population live in towns, in cities. And for them, their business, their enterprises are a means of their survival for them and their families. And so I don't really quite follow how we can somehow return to an agricultural past. I think it'd be a very retrograde step. And I think that the commercial law is now, especially contract, is of absolutely fundamental importance to our economies.
And just to add on to what Philip has said, it's interesting that Philip has said that most people now working cities don't work on the land. This, of course, is how law started in Roman times, with the foundation of cities. The reality is that we could not have civilization without commercial law. Throughout history, that we never could have. I've endeavored to explain that since 500 BC, this has always been the case. If we do not explain it, nobody else will. The lack of knowledge and interest in academia about law's contribution to civilization is quite astonishing. So it really is up to us to make the explanation.
Thank you. The next question. This classification is very interesting. Are you also looking at key indicators outside financing and insolvency law? If yes, can you name the major indicators? What role does methodology play?
I should think somewhere between 100 and 150 indicators. I've only shown 3 of them, just because they happen to be ones which are very measurable and economically important. But if you look at in the corporate sphere, I mean, when you're looking at debtor-creditor relationships, which is what finance law is about, it's really just some people, people are on a spectrum. By the way, I ought to just mention at this point, when I talk about legal systems like this, there isn't a wrong or a right. You can't say one's bad and one's good in that sense. All of the major legal systems are on a spectrum, and each of their positions has got are things which fall well within the area of reasonable debate. So it's not. I'm not saying one is wrong or one's right. I'm just saying we have this big range of opinion, which has the advantage that people can choose a legal system for many things, and that means there's a degree of competition. But they've all been immensely successful. The 3 great legal systems economically and every other way. I mean, they've been an enormous civilizing force in the world. And I think the achievements of those three big groups, what I call the triple polarization, has just been astonishing. And they don't have to harmonize, you know. Why can't people follow a particular philosophy, a particular ideology? I think it's perfectly reasonable. And, you know, and so what I'm really trying to do is as impartially as I can to measure what the differences are so that people can make up their minds. So if you take corporate law, for instance, it's quite, I wish I'd been a corporate lawyer actually. It's more complicated, you know, because you haven't just got a single line. You've got three or perhaps four people to take into account. You've got the shareholders, the management and creditors. So it's a triangle. And if you take Delaware law, who do they look after? Management, management, management in their takeover code with poison pills, in their, there's no director liability for deepening insolvency. You know, there are a load of indicators you can take which show that in England, we're either looking after shareholders or usually creditors. If it's creditors versus shareholders, we look after creditors. And I think in France, it's also a different position. So if you apply these indicators, of which I say I've got easily 100, and you drop them into a legal system, it's like litmus paper. You know, it comes out blue or red. And if you put them all together and you accumulate them, you can aggregate. And to me, it's amazing to see, like shaking a kaleidoscope and all these colors. They're just simple pieces. And you get these quite fantastic arrays of different colors. Just most incredibly an exciting thing to do, to find how people are edging forward and trying to work out how they embed, you know, their convictions into their legal system in these very different ways. For me, it's just amazing. A very attractive and very exciting thing to do.
Thank you, Philip. There's quite a few questions actually. We probably won't get through all of them, although I would like to reassure everyone who sent one in that I'll put these to Philip and John afterwards, and we will circulate the answers with the recording. Another question here. Thank you for this very interesting presentation. What is your prediction about the increase of law? Will it ever come to a peak, or will there even be a reversal?
I think the law is out of control at the moment. I think we need a flamethrower. I think it's just impossible. I mean, people are being forced into smaller and smaller areas of law. And look, you know, if I go into, when I was trying to write books, I went into somebody in the room and said, I just don't understand this about CDS, you know. And she said, look, I only do equity options. So, I mean, that's just in derivatives. And look, it's out of control. And what we do about that, I mean, there are lots of things. Hopefully, artificial intelligence is going to help us, but we're still in the foothills of the accessibility of law, and getting artificial intelligence somehow to reduce and find the commonality and concentrate on what the differences are. I think we've got a long way to go on that, but we certainly can't go on like this. But at the moment, it looks to me like we are, particularly in regulatory fields, which I think are too big.
And we were getting to the point, or probably past the point, where an individual simply cannot be expected to know what the law is in a certain area. Even specialists don't really know fully what the law is. So somehow I think we've got to reduce the scope of the laws that have been passed.
Thank you both. Another question for you. Have you read or looked at Fernanda Piri's recent The Rule of Laws? It seems to offer a fascinating anthropological approach to the history of law. I'm about to start on it, unless you advise against that.
Well, I'm afraid I haven't worked. I mean, there are lots of works I haven't read. It's very difficult to keep up at the moment. And I personally have just written 2 books, so I'm sort of adding to the enormous pile. But one thing's for sure, that the whole idea of law is very old. You know, it goes well back to 3,200. I'm not saying it's older than religions, but they are very, very old. And they differ from religions in the sense that they've got an enormously wide coverage. If you take the digest of the Romans, which is 1.5 times the size of the Bible, which was put together in 535, and compare that to the Quran, which also had quite a significant legal content, what the Quran covered and what the legal systems covered is very different than the Digest covered. Just no comparison. So law really took off as the upholder. The laws became the scriptures of our society. They are the scriptures. Now, sometimes the scriptures are used to rant and rage, but on the whole, I think most societies have treated their legal systems with a measure of respect and realized how important they are. You don't get, I think, sort of wanton trampling all over legal systems. They are felt to be our scrolls,
Thank you. And the one last question, there are still a couple more, but as I said, they will be addressed by Philip and John. But the last one is, per Philip's challenge at the outset of his talk to identify the 7 jurisdictions of Britain, I have 6: England and Wales, Scotland, Northern Ireland, Isle of Man, Jersey and Guernsey, but cannot think of the 7th. Please could he confirm what it is? Thanks so much.
Alton-in-Stock.
Well done. I'll send you a bottle of champagne. Actually, thought that there's another one called Le Brut, but I'm not too sure about that.
Okay. Well, thank you both.
You have to have a certificate from the University of Caen to practice in Albany and so on.
Thank you. Thank you both so much. And thanks to everyone who's joined us for this session. We hope that you've enjoyed this very informative talk. We're keen